Under what circumstances can the federal government implement a land use moratorium to protect public health? The D.C. Circuit considered this question in Alabama Association of Realtors versus United States Department of Health and Human Services. In 1944, Congress passed the Public Health Service Act, which authorized the Department of Health and Human Services to enact regulations necessary to prevent the interstate spread of communicable diseases. The act permitted the Secretary of the Department to determine whether preventative measures were needed and to enact those measures that the Secretary judged necessary. In 2020, the COVID-19 pandemic disrupted the U.S. economy, leading to concerns that large groups of renters would be evicted for non-payment of rent and thus would be forced into homeless shelters and other forms of group housing where the virus was likely to spread. In response, the department enacted a nationwide temporary eviction moratorium. The moratorium prohibited landlords from evicting economically disadvantaged tenants who, if evicted, likely would be forced into shared or congregate housing. Tenants were still required to pay rent, and the federal government was providing additional COVID relief, including rental assistance. The Alabama Association of Realtors filed suit in federal district court opposing the moratorium. The association argued that the moratorium was improper because states, not the federal government, had authority to regulate housing transactions. The court granted summary judgment in favor of the association and vacated the moratorium. The department appealed to the D.C. Circuit.